Good morning, everybody. My name is Alex Barthet, and today I will be hosting the webinar, The Top 3 Avoidable Lien Release Mistakes that you need to know about. Ariella is out of town, so I'm going to fly solo here. So let's get started. So on today's agenda, we're going to talk about the 3 mistakes that I see as a board-certified construction lawyer here in Florida that clients make all the time or have the most questions about with respect to releases. So mistake number 1 is using the wrong form. Mistake number 2 is not using conditional release language when they need to. And mistake number 3, using the wrong through date or not understanding the significance of the through date in the release. So mistake number 1, using the wrong form of release when it comes time to exchange money for a release. So what form of partial and final waiver of release should you use? Well, it depends primarily on where you are in the chain of contracts. Are you the general contractor? Are you a subcontractor? Are you a sub-sub? The general rule is that you want to give a narrow release, giving away the fewest amount of rights when you get a check. And when you are giving a check to anybody, whether you're the GC giving it to a sub or a sub giving it to a sub-sub, you want to get the broadest release that you can possibly get when you hand over that check. So let's look at some forms of releases so you can understand the language that I'm talking about the distinction between a narrow release and a broad release. So let's start with the basics. The statutory Chapter 713 releases. This is the lien statute, Chapter 713. So let's look at what the forms that exist in the statute say. So this is the standard 713 release upon progress payment. And it says the undersigned lienor, in consideration of the sum of some amount of money, this is where you're going to fill in, if you're expecting a $22,000 check, you'll write in $22,000 there. Hereby waives and releases its lien and right to claim a lien for labor, services, or materials furnished through, and then it has a through date. This is the date that amount of money represents. So if you've done work through the end of the month and that gets you a $22,000 check, then you'll put the end of the month in the insert date section and $22,000 in the amount. What this release gives away is your lien rights in exchange for a partial payment. Now let's look at the statutory final payment release form, and you'll notice that the language is almost identical. It has a little spot for you to put in the amount of money, but what's missing is a through date. It has no date with which this amount of money represents the work you've done. And the reason is because it's effective as of the day you give it. So the only date in the document is the day you sign it. So if I hand someone a final release, it has no through date, and I sign it and date it today, what I am doing is I'm giving away my lien rights through today, from today back. It's illegal in the state of Florida, unenforceable, to give away lien rights in advance. So if I am asked to sign a lien release that says I'm giving my lien rights away for work in the future, even if I sign it, that is unenforceable. So if I date it today and it gives away my lien rights through the end of the year, anything from today forward is not going to be enforceable. Anything from today back is, anything from today forward is not. So let's look at some other forms of release. Now, you'll notice this form, which is a custom form. This is not anything found in the statute, is already very different because it has a lot more words. And more words should start sending up the red flag that, wait, something is different here. So let's break down each of the component parts. So the first is that it says $10, and we're going to talk about that in a little bit. Notice the rights that it's giving away in this release. So it says that in exchange for some amount of money, you are releasing any and all claims, change orders, works, materials, delays, fees, costs, losses, expenses, damages, or sums which is effectively a broad release. So when I was talking to you before about a narrow release, that would be the statutory releases. All you're giving up are lien rights. You may have other rights, but the rights you're giving up are lien rights. This is a broad form of release. This release form releases everything, effectively any and all rights that you may have. So if you were the party that was giving a check and getting a release, you want a release that has a release of all the rights, right? You want to know that if I'm the general contractor and I hand my sub a check for $50,000 and they give me a release, I want to know that that sub is not going to come back because the job went long and submit a claim for extended general conditions. And the way you do that is by getting a broad form release. The same is true if I'm a sub with my sub-subs, but the converse is also true. If I have claims against the contractor, I want to make sure that when I get the check, if I'm trying to preserve those rights, I'm not giving them away in my release. So this is the type of language you need to be aware of when you exchange a release for a check. Let's look at some of the other parts of this. It has a through date as well. So just like before, the amount of money and the through date have to match, and we're going to talk about that later. It also has some language there at the bottom about certain representations and warranties about people being paid and the work being done. Again, those are additional representations that if I am a contractor, I would like my sub to make to me that he's paid all his bills. But the same is true in reverse, right? So if I am signing this release and I haven't paid all my bills, then I have to be careful about representing that I have when the release has language like this. We generally find that most sophisticated contractors, and most contractors are pretty sophisticated these days, are going to have broad releases like this that they're going to expect their subs to sign. So you need to be aware of that when you exchange your release for the check. So if you agree to a form of release in your contract, or your contract with the contractor says something like, you agree, it doesn't have the exhibit, the release is an exhibit, but it says that the form is that you agree to provide a form that's acceptable to the contractor, then you may be bound to that form. So when you negotiate your contract with the contractor, or if you're a sub-sub and you're negotiating with the subcontractor, you need to make sure that you look at those exhibits. What form of release is the contractor expecting you to sign and turn in with every pay request? If you have an issue with it, you need to deal with it at the time that you sign the contract. Don't wait until you've signed the contract, agree to a form, and then want to object to it later. That's much, much harder to do. So that's mistake number one. Let's talk about mistake number two. Not using conditional language in your release when you are exchanging a release for a check. So how do you make a release conditioned upon actually getting the money? So let's explain what a conditional release is so everyone's on the same page. If I give you a release today and it says that I've been paid and I haven't been paid, and that release goes from me as the, let's take an example, I am the subcontractor. That goes to the subcontractor who then hands it to the contractor who then hands it to the owner. And it's not conditioned on me actually getting the money. It represents that I actually have been paid. And then the owner hands a check. Now the owner is handed a pack of releases from the contractor. The contractor's release, the subs, your release, and the owner writes a check to the contractor. And then the contractor pays the sub, and the sub never pays you. And you say, okay, well, I haven't been paid. I'm going to put a lien on the property. And the owner, once they get the lien, says, what are you talking about? I have your release. And you say, well, I haven't been paid. And the owner says, well, it doesn't matter because I relied on this release that was given to me, and it's not conditional. If that were to occur, you would have no lien rights. And the reason you'd have no lien rights is as between you, an innocent party, and the owner, also an innocent party, the courts have dealt with this issue and they have determined that as between the two of you, the owner is going to win and you are going to lose. So what does this mean? This means that you need to make sure that if you are not getting a check at the time you're giving your release, then you need to make sure that your release is conditional. How do you do that? You can add language to make it conditional. So here is sample language that says that. Notwithstanding anything to the contrary, this waiver and release is conditioned upon and not effective until the undersigned receives paid funds of, and it has a blank. So if you're expecting a $25,000 check, you're going to write in $25,000 along with this sentence. You can go ahead and write that in by hand. You can type it in. We have some clients that have made a little stamp. You can get a stamp for 10, 15 bucks, and it says this, and then when they want to make the release conditional, they stamp it. So that's how you're going to make your release conditional. So here are some things that you need to be aware of. Watch out for releases that are titled as conditional, meaning that the document says conditional release, but when you read it, it's actually not conditional. It doesn't have that express conditional language that I had from the prior slide. You need to indicate the amount of money to satisfy the condition. So if you're expecting a $25,000 check, it has to say that it's expressly conditioned on the $25,000 that you will receive. As a general contractor, if you get a conditional release from your subcontractors, right? So if I'm the GC and I hire the plumber, and the plumber has a supply house that furnishes the materials, and the supply house hasn't been paid yet, so they give a conditional release to the plumber, who then gives that release and his release to you. If I'm the GC and I give a condition and I get a conditional release from someone that I'm not actually paying, then you have to be careful, because if you pay the plumber and the plumber doesn't pay the supply house, this release that I received as the GC from the supply house that's conditional is now no good because they never got the money. So to the extent that you are the GC handing out checks, getting releases, you need to deal with that by either telling the sub, nope, I need that supply house to provide an unconditional release, or you need to issue a joint check. So if you get a conditional release, then you don't pay the plumber directly. You pay the supply house with a joint check. So a joint check is a check payable to two parties. So it'll say ABC Plumbing Inc. and it'll say the word and, not a slash, and you're not going to just stack the names. It has to say and XYZ Plumbing Supply House. And then one party will endorse it, the other party will endorse it and pick it up. Now you know that the condition of the conditional release has been satisfied. So if you have any doubt that someone's going to satisfy the condition on a conditional release, then you need to issue a joint check. So that's mistake number 2. Mistake number 3, using the wrong through date. Let's talk about the through date and why it's important. What through date should you use, and what if the through date and the payment don't match? So you need to remember that the through date is the effective date of the release. Now, every release is a little different, and it may have the through date written in different places and in slightly different ways. The through date, assuming it's a true through date, is the date that the release is effective up to. So I may sign a release today for work that I did through the end of January. So the through date would be the last day in January. The most important thing you need to remember is that the through date will control over the payment amount. So let me give you an example. So let's assume that I'm a subcontractor on a job and I submit a pay application for $100,000. Then I show up to pick up the check, and there's only a $75,000 check. And I say, wait a second, I'm supposed to get $100,000. So I say, well, it doesn't matter because I submitted my pay app for $100,000. I'll go ahead and sign this release through the end of January. And I just know that it's more money that's owed to me. Here's the problem. If you pick up a check, especially a check that's a reduced amount, and your release is for that payment has a through date later than the date then you're actually been paid, then you have a problem. You need to make sure that the through date and the payment match. So for example, in my example, if you're expecting $100,000 and it gets you to the end of the month, but they're only paying you 75, then you need to change the through date to whatever matches the 75. Maybe that's the 13th of the month, maybe it's the 28th of the month. It depends on the situation and that month and the work you did and the materials you supplied. What you have to make sure of is that they match. Whatever the amount of money is that you're getting has to be representative of the through date in the document. And if they don't, then you have to change them to match. Okay, so let's talk about a bonus tip. Why does the release say $10? This is a question I get all the time. You're picking up a check for $20,000, but the release says $10. So let's talk about it. There are typically two very common reasons why a contractor may demand a $10 release. And the two most common are, number one, you have given a notice to owner on this job, but during the period in question, you are not owed any money. So let's assume that I'm a subcontractor on a project. I have issued a notice to owner, but I'm not actually going to start work for another 3 months. So the end of the first month comes and the GC says, I need a $10 release. And you're thinking, well, I haven't done any work. They are doing it correctly. The law requires that once you issue that notice to owner, then the contractor and the owner need to get a release from everyone that issued a notice to owner, whether or not they did any work that period. And if you haven't done any work that period, it is common that the amount of money recited in the release is going to say $10. So that's the first very common and legitimate reason. The second is that the contractor may have hard bid a job. So the contractor says to the owner, I'll do this job for $1 million. But now the contractor doesn't want the owner to know exactly the amount of money that the contractor is paying to all the subs and suppliers. So they want to only hand the owner $10 releases so that the owner doesn't go through and say, well, the plumber, this release says $22,000, this supplier says $94,000, and they go through and they add up the amount and they realize, wait a second, I've paid this contractor too much money. So sometimes contractors want to shield how much information is given to the owner. That is another common reason why contractors want to get from you a $10 release. When that is the case, what you as the sub should do is you should say, okay, I'm expecting a $50,000 check. I will give you a release and it should say $50,000 on it. Once that check clears, then I'll give you a release that says $10 and you can hand that to the owner. But the general rule is, come on, the $10 releases are valid if you receive any amount of money, no matter what. Even, by the way, of the consideration that you receive, I should say, it's any amount of consideration, even if that consideration is not exclusively money. Maybe you gave up other rights. You don't always have to get money in exchange for a release for that release to be valid. If you're the one getting the cash and giving a release, you should always try to include in the release the amount of money. So if I'm expecting a $25,000 check, the preference would be that if it says $10, you strike it out and you write $25,000. And the reason this is important is that if someone does try to short you on your payment, at least you have some ability to argue that you were expecting a $25,000 check, even and you got a $20,000 check. Well, then maybe this release isn't fully valid because you didn't get all the consideration you were expecting. So if you're getting a check and giving a release, you should try to strike out $10 and put in the amount. If you're giving money to somebody and getting a release, it's always better to try to get that release to say $10, because then you don't have to worry about someone coming back saying, well, I gave you this release and I was expecting $25,000 and you only gave me $20. Those arguments go away when the release says $10. And of course, you cannot make a release conditioned on $10. So if you're going to have a conditional release, it has to be conditioned on actually the amount of money that you're expecting during that period of time. If you are interested in learning more about construction law, we have a weekly podcast that we publish at our website called The Lien Zone. So if you go to iTunes, Google Play, Stitcher, or wherever you get your podcasts, you can do a search for The Lien Zone, TheLienzone, all together, and you'll find our podcast. Comes out every week. We've been doing it now for more than 2 years. Very short podcast, generally between 3 and 10 minutes long. Occasionally we'll have a longer one, and we typically deal with a topic about releases, liens, bonds, collections, contracts, to help you better navigate the issues you are dealing with, to see if you to better improve your processes.